Brought to you by GTA, your island, your network.
Do you believe this is a race issue?
Well, there's no question about that.
Attorney J. Christian Adams is representing Arnold Dave Davis, a Guam resident who several years ago filed a lawsuit against the Guam Election Commission and the Government of Guam after he was prohibited from registering to vote for Guam's political status. As it stands, Guam law only allows native inhabitants or a descendant of one who was naturalized under the Organic Act in 1950 to register and vote in a plebiscite. Adams argued ancestry is the same as race.
The Supreme Court has said that ancestral qualifications, who your grandfather was, who your daddy was, that's the same thing as race. When you start using blood to determine who gets to vote. Blood should not be a requirement for voting rights. It's what this country got rid of when it had a civil war and civil rights movement.
Special Assistant Attorney General Julian Uggan disagreed, saying ancestry is not always a proxy for race, but can be. He says this doesn't apply in this case, however. He added Adams is trying to, quote, disguise an attempt to block the exercise of the fundamental human right of self-determination beneath the guise of civil rights, which he says is repugnant. Native inhabitant, he adds, is not a racial classification.
I think we argued our motion really well, our motion for summary judgment, because it is so clear that he has not proved that the challenge statute, which is the Guam Decolonization Registry law, is infected by any impermissible intent, and he hasn't proved that there's any racial classification at issue.
Attorney Adams argued that if this wasn't race-based, the law wouldn't have included descendants or a bloodline of Native inhabitants. The law, he says, doesn't implicate adoptive children of Native inhabitants either. Adams says if the judge rules that ancestry is the same as race, the registry would violate the Equal Protection Clause in the 14th Amendment, the 15th Amendment, the Organic Act of Guam, and the Voting Rights Act.
The right to vote is a fundamental right. It applies to everybody equally, and people have a right to participate in the political process. It's in the Constitution, it's in the Organic Act, it's the right thing to do.
Uggan, however, argued there's no violation of constitutional rights, as this plebiscite isn't a vote, but instead, quote, purely a symbolic exercise and expression of political opinion.
One of our chief contentions was that a purely symbolic political status plebiscite is simply beyond the reach of the 15th Amendment or the Voting Rights Act. We believe that neither of those things cover the political status plebiscite at issue in this case. And so, of course, we believe that plaintiff Dave Davis is simply not entitled to the relief that he seeks in this court.
Uggan noted Congress may not even do anything with a plebiscite should it ever happen. He further adds not all sections of the Voting Rights Act applies to Guam because we are a territory and not a state. Adams disagrees.
The government is trying to say that the Voting Rights Act doesn't apply to Guam. That's dangerous for people who live here. It would be the first place where the American flag flies that you don't have the protection of the Voting Rights Act. Today's majority is tomorrow's minority, and everybody should support voting rights no matter who your grandfather was.
Both presented their arguments for nearly 6 hours. The courtroom was filled with senators, members of the administration, the Guam Election Commission, and Chamorro activists. Judge Frances Tydenko Gatewit said this issue is not only important for the court, but the entire island of Guam. She said she will take the matter under advisement and issue a written decision and order soon. Reporting for Guam's News Network, I'm Ken Quintaniza.
Brought to you by GTA, your island, your network.